All right, so this is chapter 2 called the early treaty era. And the early treaty era includes the era of the United States independence all the way up to the ratification of the federal Constitution. And that period is usually referred to as the Articles period, or the Articles of Confederation period, or the Confederation period, because the federal government as we know it was not really in existence, and it was very dysfunctional. So the United States existed as a power between the Battle of Yorktown, in which Lord Cornwallis was defeated, and 1789, okay, when the Constitution of 1787 was finally ratified by the state of New York. It was New York. Okay, so that period from 1781 to 1789, the 80s, the big 80s, was a period when some early federal policy was developed, but most of it came right around 1787, 1789. Okay, I won't go into this right now, but this is a little blurb in your textbook called, it's a letter from George Washington to some other military guy, I guess it was. But the point of it is that in the early days of the United States, we were so weak. The federal, the United States was really lucky at Yorktown to have defeated the British. And the British had already been fighting other wars, and they had their military drained. They were sort of like Russia is right now. They didn't need another war. So the British kind of cut bait and left. And but everybody kind of expected the British will be back. They'll come back and they'll reclaim the place. They always do. So it was very much expected, and they did. 1812, they did. So anyway, it was very much expected that the British would retake the American colonies. So that meant that George Washington and others realized that if they were going to successfully survive a potential British invasion in a few years, they didn't need to be at war with Indian tribes, right? So they did, and they did their very best to, and this document kind of throws some things out. You might even be kind of shocked at what the father of our country had to say about the tribes. Basically was saying, well, it'd be a lot cheaper for us to just buy their lands rather than slaughter them. Okay. Anyway, he didn't say it that snidely, but more or less. Okay. Now some important things that did develop in this period were what are referred to as the Trade and Intercourse Acts. And I'll try to get this all typed up, but maybe, if you can read my chicken scratch. What the other name for these laws, and some of them were after the Constitution, were called the Non-Intercourse Acts. Okay. Well, you can kind of go all over. I mean, you could probably think of a comedy routine on these terms, but with what happened to the Indians, Anyway, the Trade and Intercourse Acts, or the Non-Intercourse Acts, were passed in 1790, 1802, 1834. And what that did was it basically reiterated the old British policy of keeping the local people out of the relations between the central government and the Indian tribes, okay? Because the British had realized that, you don't want the locals making up policy about making up Indian policy. They're their enemies. Okay. So that's the main reason why we have a number of documents that specifically remove the states and local people in the states from having any authority to interact with Native American people and tribes. So the central policy was basically you separate the Indians from the non-Indians. It created boundaries, Indian country versus the colonies. So the term Indian country arises at this time. Federal control was exclusive, and there were protections expressed in these non-intercourse acts. There were statements that said basically, if our people, if the non-Indian people in the colonies go into the Indian country and become mischievous, essentially what they're saying, if they commit crimes against American Indian people, against tribes, then they are not under the protection of the central government. That is wrong. They recognize that's not something that we want. So basically, it prohibited whites from purchasing land from Indians. It protected against non-Indian incursions into Indian country, because that was happening. It prohibited whites from settling on or entering Indian country for hunting or grazing. People who wanted to set up trading posts to trade furs or deer skins or whatever with the local Native American people had to have a federal license. The so-called Indian agent, or the Indian trader in this case, had to have a federal license to be involved with Native peoples. Any non-Indian depredations upon Indian people and Indian tribes were made into a federal crime. Okay. And the federal government provided compensation to the Native American victims of those crimes. Basically, our people did a wrong to your people. We're going to try to make amends and pay you for that because they were bad. These early laws, these early federal laws, did not regulate the conduct of Native American people upon other Native American people. That was considered completely out of the responsibility, the purview, the jurisdiction of the government. That's their thing. If the Shawnees want to wage a war against the Cherokees, or if the Cherokees want to go out west and slaughter the Osages, or if the Osages want to go down to the southwestern parts of Oklahoma, not Oklahoma, and slaughter the Kiowa, all of those things happened, then that's their business. That's not the United States business. That's their business. Even if the United States claims the land, which it did, where those Native peoples were doing those things, that's not our responsibility. That's the Indians' business. That's the tribe's business. All right. Well, now we move into this era known as the early treaty era. And a most important figure in this era is a man who became Chief Justice of the United States Supreme Court. He has numerous schools named after him. You've probably heard of John Marshall High School in Oklahoma City. John Marshall, Chief Justice of the Supreme Court, was still considered probably the most significant, most important Chief Justice of the Supreme Court of all time, largely because he moved the Supreme Court from obscurity among the three branches of government to actually having a great role in the federal government. And part of that removing the Supreme Court from obscurity involved the development of Indian law and Indian policy. Not all of it, but some of it. Now, there's something called the Marshall Trilogy, which refer to three specific Supreme Court cases in which that were heard during the Marshall Court. By the way, there is also another Marshall that's really significant in the Supreme Court named Thurgood Marshall. And actually another one too, but don't confuse them. John Marshall was the early 19th century Chief Justice. And the first of the three Marshall Trilogy cases we're going to talk about here is Johnson versus McIntosh, 1823. The other two we will discuss next time, and they are generally referred to as the Cherokee cases because they both involve the Cherokee Nation after the Indian Removal Act. Okay, so let's move on to John Marshall here. Johnson versus McIntosh, probably, if you asked legal scholars, Indian law scholars, probably would say Johnson versus McIntosh is in the top 5 of the most important cases ever. Some might say number 1 for sure. But anyway, this is the citation for that old United States Supreme Court case, 1823. It didn't even involve an Indian. Okay, it was actually about title to land that had earlier been purchased by a British citizen from a Native American person. But the actual case involved a challenge to the legitimacy of a title to the land, to a parcel of land, actually most of Kentucky. All right, so the case was, you don't really need to know the specifics of the case, except that it involved title to the land. Now, how many of you own automobiles? Okay. What if somebody, maybe you left your keys in your car, and maybe somebody stole your car? So what do? You go to the cops, right? And say, hey, somebody stole my car. What are they going to ask you? And what's the license plate number on it, right? They're going to ask you, you're going to say, for example, they can't find your car. Most cops can't. Stolen cars are lost all the time. It gets, goes to the chop shop and you never see it again. So you go to your insurance company, all right, State Farm, and you say, hey, somebody stole my car. I want to be reimbursed. Can you reimburse me the money on that? Well, okay. Supposedly you have a policy with them. They're going to say, yeah, we can help you because we have all the information about your ownership to that vehicle. What is that document called that verifies your ownership over that vehicle, Title, yeah, the title. What happens when you lose the title? Now you have to go get a new title and it costs you some money. What happens when you sell your vehicle to somebody else? You have to sign the title over. Remember doing that? You've ever done that? Or maybe you've bought a car and you had to sign, the person signed the title over to you. You had to take it and get it notarized and all that kind of stuff. You had to take it to the tag agency and they put it on file and they sent you a new title. Okay. That's your proof of the ownership of that property. Okay. Now in a Western European tradition, we make everything property. As much stuff as we possibly can is property. Okay. It's a different story. You have to read about Karl Marx and read Adam Smith and all those people to learn more, Thomas Hobbes and all these wonderful philosophers who really were fascinated by the infatuation of European people with property. Okay. I mean, they made the land into property, like you can own it. Isn't that ridiculous? I mean, you can own a car and you'll probably drive, maybe you could drive it 20 years, but you'll probably outlive the car. Okay. I own the cell phone. Okay. I don't have a title to it, but I purchased it and it's mine and Apple knows it's mine and all that kind of stuff, but I'm not going to have it forever. I'll get a new phone. But what if I own land? I'll never outlive the land. So I have to get rid of it somehow, right? Okay. So there are, Europeans have placed they've commodified the land. They've commodified everything. We even commodify our thoughts, you know? Anyway, so you have property. And in this case, Johnson versus McIntosh was about the exchange or the transfer of property. And it came down to basically this. The person who was challenging the legitimacy of the ownership title to a parcel of land was saying this: that land, you don't own that land because you purchased it yourself from an Indian tribe. And the Indian tribe cannot sell the land to you. All right? The Indian tribe cannot sell the land to you because you are not a sovereign. It's basically what it came down to. And so in this very convoluted case, Chief Justice John Marshall came up with an idea, with a theory, with a doctrine, a legal doctrine, known as the European Doctrine of Discovery, okay? The Doctrine of Discovery. And that goes like this. Only sovereign states, okay? Only sovereign states that have legitimate governments like those in Europe, whether they be Great Britain or France or Spain or Portugal or the Netherlands or whatever, only sovereign states have the right to claim lands far from their boundaries as their own. Now, it takes a little mental gymnastics to get this through, but this is what John Marshall was saying. He said that it's the sovereign that has the exclusive title over the land claimed by a great power. That exclusive title is only held by those sovereigns. The native peoples who live on the land are more or less kind of like the trees and the water and the topography. They're part of the land. Back in the 60s, a lot of native people might have said, yeah, we're part of the land. But the Europeans actually used that to their advantage. They said, the Indian people, they belong to the land, they live on the land, they make their living from the land, they belong to the land, they're part of the land. And so the Europeans discover and lay claim and stick a flag in the beach sand and say, this is ours, okay? And when Great Britain lost the war to this set of colonies that became the United States, the transfer in 1783 in Paris, that transfer of claim of exclusive title by the sovereign of Great Britain was transferred formally to the sovereign of the United States in Congress assembled, okay? So that transfer of sovereignty is the way that Marshall interpreted things worked. And if that's the case, then this has to be the way things operate. Only the sovereign power who has exclusive title to the land can take or can purchase land from those who have another type of claim to it. In this case, he called it original Indian title. The Indians have a right to that land. They have a right, this is Marshall talking. The Indians who live on the land have an absolute God-given inherent right to use the land that they live on. But it's not quite as good as what England and France have, okay? But there is something that basically Marshall dreamed up, and that is the concept of original Indian title and the concept of the doctrine of discovery creating exclusive title by the state. All right. So the little nations of native peoples, they're sovereign. They have a right of use to the land. They don't own it outright. They certainly can't sell it to, let's say, Spain or France. Okay, that would be a problem. So the United States is saying, and John Marshall is saying, that these Indians can't possibly sell it to anybody but the sovereign United States. That's where this comes from. So Johnson versus McIntosh created all kinds of basic foundational, important foundational relationships. Basically, that the federal government is exclusive. Only native lands can be ceded by a Native American tribe. They can be ceded by an Indian tribe, but they can only be ceded by an Indian tribe to the United States. They can't be ceded to an individual or to a company or to a foreign government. They can only give the land to the United States. Then that means that only the United States has the right to extinguish the original Indian title. That is the right of use to the land. That's the very basic component of most every Indian treaty. The Indian title to the land is not the same as the exclusive title. It's older, okay? And the courts are recognizing that it's older. Let me tell you one last thing. And I think we'll probably hang it up. I don't think anything else here is really that impressive or important. I'll bring it into other parts, but so it works like this. The Indian tribe, the United States government has a monopoly on Indian land, right? The United States government can purchase, or it can take Indian lands that Indian tribes cede through treaty. Cede means give up. They can give the land to the United States in a treaty, typically for some sort of return, some sort of compensation. Okay. And only the United States federal government can extinguish the original Indian title, the original right to use that land by Indian tribes. Only the government can do that, which means if it does so, if a tribe cedes the land to the government and the government extinguishes the Indian title forever, then the government can convey that land or parcels of that land to non-Indians. That's the way it works. Okay. Now I want to leave you with one important thought. And a lot of people who don't know doodly squat about Native America often make this mistake. They say things like, well, we gave them the Indian reservations, they should be happy enough, right? Or, that's government land on that Indian reservation. Or we took the land fair and square. Or we took the land, we cheated when we took the land, but it's still ours, or something, stuff like that. Okay, there is something really, really important to remember. American Indian tribes never, ever received a damn thing from the United States. All right? They only gave to the United States. The United States was the receiver in every situation. The United States was the one who received, and the Indian tribes gave to the United States. All right? But they only gave what they specifically gave in the treaty. Everything else remains, unless it's absolutely expressly ceded to the United States government. Native American Indian tribes who have a claim on land retain other rights to the land. All right. What's that mean? That means that in an Indian treaty of cession, say, for example, the Ojibwe are giving up some land to the federal government that the federal government wants for the homesteaders. And the Ojibwe cede the land, but they don't cede their rights to hunt on the land, or they don't cede their rights to safe passage across the land, or they don't cede their rights to fish on the rivers that flow through the land. If they don't expressly give those rights up to the federal government, they still have them. And that's what makes things really, really interesting, okay? I'm probably blowing enough here. So you all have anything you'd like to comment on or discuss before we go? Well, here's an interesting map. This is not a great map, but if you have when you get an opportunity, go to that first exercise, which is kind of a quiz, and open up the browser or open up the link in your browser and explore Native America or explore Indian country. Okay, explore Indian country, and you might be kind of surprised at what what you see on that map. The quiz won't take you more than half an hour, I don't think, but you should all make 100 on it. Make sure you don't make any mistakes, and go ahead and submit that, and it'll be your first grade. If you don't have any questions, you can always email me questions. You can text. This is only 7 people in here. I think only 6 showed up today. You feel free to send me a text message if you want. I check my email pretty frequently. Email is formal, email is legal, all that stuff. But I know folks these days tend to like their answers just quicker. And what we need to do next time I almost forgot. Let's see here. Yeah, here we go. Next time. Here's your homework reminder. Before Wednesday, you have 4 quizzes to get done. You're gonna make 100 on all of them, I hope. They will open up to you sometime tonight. But go ahead and, before you even try to do a quiz, be sure to read about the material first. So if you got your book, great. If you got to use a PDF, that's fine. But go ahead and spend the next day trying to get those readings done. They're pretty fast. You don't have to go through them with a fine-tooth comb necessarily. And open those quizzes once you get a handle on that. I may not have them all ready tonight or before. I'll have them done before midnight. But anyway, go ahead and get started on that. And then also you'll have to go to today's kind of heavy duty day. Go to the Wednesday class meeting and try to complete the reading assignment for that, because that's what we're going to talk about next time. It's a lot of material, but again, I'll have slides and stuff for you. And also have a look at those discussion questions. If you don't do anything else, look at the discussion questions and try to find those in the text and try to be ready for those. And I appreciate you, most of you being on time today. But next time you're going to be talking a lot more than me. Okay, I promise you. All right, over and out. Have a great evening. I held you late on the first day. That's awful. Okay, I'll turn this thing off, and I'll see you on Wednesday.
I have a question real quick.
Sure.
So basically everything's due on Mondays and Wednesdays is what it looks like.
Yeah, pretty much.
Okay. So will the assignments be open ahead of time? Because I know right now they open at 8:40.
Yeah, the quizzes, are you talking about the quizzes or the exercises?
Probably the quizzes is
The
what I'm
quizzes,
thinking.
yeah, the quizzes will open automatically at 8:40. Although I probably got to turn one of them off because I don't know if it's ready or not yet. But once I get them all loaded, I haven't got them all loaded yet. They will open right as class gets out, and that's when the material is supposed to be fresh on your mind.
Okay.
Okay.
So
But
having
if you do the if you complete the reading assignment before class, and we'll talk about it, then you can take the quiz when it'll open up immediately. And it's due, like the quizzes, the 4 quizzes that you need to do now are going to be due by 5:30 Wednesday. Okay. Now, most people will probably get them done before that, so hopefully I'll be able to look at the results a little ahead of time, but that's what I'm shooting for.
Okay, I was just wondering if there was enough time to complete it.
Yeah, and again, they're not timed, and they're not necessarily long quizzes. They're directed at certain points. So it's not like a comprehensive quiz over everything in the book. Okay.
Are the exercises pretty long or no?
No, the exercises are worth 8 points apiece. So
And
the quizzes are only worth 4 points apiece. So not really, they're not worth points actually. The quizzes are only worth 8 points apiece, but they're more like directing you, giving you sort of guidance on how to do things. They're not intended to be like a summative assessment, like a test. So
okay.
yeah, the schedule is there to kind of keep you rolling, keep you on schedule, keep me on schedule, and otherwise this class can get brutally behind because it's 8 weeks is a really short period. So
Okay, and we do have discussion posts, or did you just mean the discussion like next?
oh no, just verbal discussion. I don't do any of that discussion stuff, texting and all that, or posting and things. Doesn't work for me.
All right. Thank you.
All right, have a good evening.
You too. Thanks.